Good evening and welcome, ladies and gentlemen, to the last lecture of the Selden Society for this year, Sir Gerard Brennan, Constrained Compassion. On behalf of the Selden Society and all of us present, I acknowledge the Jagera people and the Turrbal people as the traditional custodians of the lands on which this court is located and where we meet today. In a spirit of genuine reconciliation, I pay our respects to their elders past, present and emerging. I was given this privilege to introduce our most distinguished speaker because I once worked for Sir Gerard, as did others, or other Queenslanders such as Roslyn Atkinson, Roger Darrington and John Bond, all of whom are here today. On his appointment as Chief Justice of the High Court, Sir Gerard created a new role called the Executive Associate to the Chief Justice, and he based it on a similar position in the Canadian Supreme Court. So apart from assisting all the constitutional cases, the role would also help in his speech writing, an unenviable task, and liaise with the press and both branches of government. He phoned me at Bond University the day it was announced that he was the next Chief Justice and asked me to come to work for him immediately. Why, he asked me, that's another story, but of course I couldn't refuse. In that role, I had the great privilege to witness Sir Gerard assume the role of Chief Justice, and the best way to describe him in my mind is that he was like a chief engineer of a very delicate piece of machinery. Now, I've never thought of Sir Gerard as a mechanic. I'm not sure what his record is with cars, although he did always have a Volvo when I knew him. But when you think about the judicial system as a very delicate piece of machinery, it's part, of course, the whole constitutional system that we enjoy, and it is a delicate piece of machinery overall. And he was the custodian, as Chief Justice, of that judicial branch. And it's well recognised that he was a judge that applied and sought legal principle in every case. Any development of the law had to be based upon legal principle. But the overriding passion he had was for the dignity of every human being. And he took this role very seriously. His devotion to the law, his commitment to the law was paramount. And I remember him saying to me that in Drake's case, which was the big case where he outlined the role of the AAT in merits review and the relationship between the executive branch particularly, he said to me that was one of the hardest decisions he ever had to write, hardest judgments he ever had to write. And there he was trying to create a new piece of that machinery in between the judiciary and the executive branch. The last case I worked for the judge on was Wick, which we're going to hear about tonight. I vividly remember my last day working for Sir Gerard. It was early December 96. The whole court, all the judges had written their judgments in Wick. They were being proofed and prepared for publication. And we knew that the judge was going to be in the minority. So I said to the judge just before I was leaving, when do you think the Wick judgment might come down? And he said to me, I think it'll be a day or two before Christmas Day. So I timidly suggested, Judge, why don't you give all the government lawyers a decent Christmas before all hell breaks loose? And he got quite angry with me and said, Gerard, we never manipulate the timing of our judgments. As soon as they're ready, they will come down. So sure enough, it came down, I think, on the day or the second day before Christmas. And I always felt sorry for the government lawyers, thinking what a dreadful Christmas they had. So I checked with our distinguished speaker, who was Solicitor General of Queensland at the time, and I said, Pat, how did you cope with the timing? And he just told me that he and Shelley went to Paris for 2 weeks. So all that sympathy all those years, and then he tells me just a moment ago that it was really dreadful. So he shouldn't have gone. But anyhow, so Sir Gerard knew when his judicial duty overrode any other consideration. He was that passionate about it. Like the other former associates of Sir Gerard, we could rave on forever about him. But now to the distinguished speaker, the Honourable Patrick Keane. He hardly needs an introduction in an audience here in Queensland, but I'm conscious that there are some here who may not have met him and others listening to this interstate or even overseas. So I've come up with 4 interesting accolades. He is the first Vinerian scholar at Oxford from Queensland in 1977. That is, he topped the BCL year. And there's only been one other Queenslander since, in 2018, Christopher Stackpool, who's at the Brisbane Bar. Secondly, he's the second longest Solicitor General of Queensland, from 1992 to 2005 with a right of private practice, which probably helped him stay as long in that role. Thirdly, he's the third Chief Justice of the Federal Court of Australia, 2010 to 2013, after serving on Queensland's Court of Appeal for 5 years. And fourthly, he's the 4th Queensland-born male to be appointed to the High Court, from which he retired, according to the Constitution, in 2022. Today he is still active legally, including since last year as, like Sir Gerard, a non-permanent judge of the Court of Final Appeal of Hong Kong. Finally, I'd just like to suggest 3 special characteristics that I think Justice Keane shares with Sir Gerard. First, his own meticulous care of the judicial machinery of this country. He possesses that same commitment to legal principle with a sensitive appreciation of the judicial role within the constitutional framework. Secondly, his unpretentious character, his modesty, his generous mentoring of other lawyers, and his sociability. And thirdly, and these are all shared with Sir Gerard, his love of good wine, good food, and travel, although I think Pat's love of Paris exceeds that which Sir Gerard had. Please welcome the Honourable Patrick Keane.
Thanks very much. Thanks very much, Gerard. Colleagues, ladies and gentlemen, it's a very great honour indeed to have been asked to give this evening's lecture in memory of Sir Gerard Brennan. His professional life as a barrister and a judge was encompassed by the 5 decades after the end of World War II. During that time, he was without peer, save for Sir Anthony Mason, in the contribution he made to the administration of justice in Australia. In the roughly 3 decades since Sir Gerard's retirement as Chief Justice of the High Court, the work of Australia's highest court can be seen to consist in very large part of the working out and consolidating of the landmark developments in the law wrought by the courts on which Sir Anthony and Sir Gerard participated and over which they respectively presided. Developments in the requirements of natural justice and governmental decision-making, freedom of political speech, the right to a fair trial, and native title are the most obvious examples of the developments that I'm talking about. Many of the judgments of Sir Gerard are worthy of a lecture or indeed a book in their own right. But it's important also to remember that his legacy includes his work as the Foundation President of the Administrative Appeal Tribunal on his appointment in 1976. He established the AAT, a world-leading innovation by Australia, as a guarantor of the integrity and quality of decision-making by the executive government of the Commonwealth. The success of the institution that he so established would, in the decades that followed, inspire the Australian states to emulate the Commonwealth's initiative. F.G. Brennan QC was President of the Australian Bar Association when he was appointed to the Federal Court of Australia. Any discussion of his contribution to the legal life of the nation must include reference to his work as a barrister, both as an advocate for his clients and as a leader of the Australian Bar, as an advocate for the bar itself as an institution whose work he saw as integral to the due administration of justice. Both as a barrister and a judge, he believed that good advocacy was essential to the doing of justice. And so he believed deeply in the importance of the bar as an institution dedicated to ensuring the quality of advocacy in our courts. He was an enthusiastic adherent to the view of Sir Owen Dixon that the honourable practice of the profession of advocacy affords the greatest opportunity of contributing to the administration of justice according to law, and that there is no work in the law that admits of a greater contribution. May I take a moment then to say to those who did not see Brennan QC in action that he was truly a mighty advocate. He and his great rival, P.D. Connolly QC, stood at the pinnacle of a sequence of brilliant Queensland barristers. They were the leaders of a tradition of highly skilled advocacy in which the Queensland Bar evolved a culture of excellence, especially in the administration of criminal law, equal to any bar in the country. And may I also say to those who never saw Brennan QC argue a case that he was not only a formidable advocate, he was a passionate one. That assertion may come as a surprise to those who only saw his Olympian serenity as a judge, or who know of his advocacy only from the summaries of his beautifully articulated arguments to be found in the Commonwealth Law Reports. I remember, as an article clerk, watching him present an argument in the Supreme Court of Queensland. My firm was on the other side, but I thought that his argument was utterly compelling, truly a thing of beauty, as aesthetically pleasing as it was legally persuasive. The Supreme Court of Queensland thought otherwise and summarily rejected his argument on the spot without reserving. The lawyers for both sides left the courtroom together. It was only as all of us got into the lift to leave the building that, unable to restrain himself any longer, he exploded with genuine indignation, slamming his brief down and saying, "That decision is as wrong as hell." In 1996, the year before he retired as Chief Justice of Australia, he made a memorable speech to the Australian Bar Association. In a few lines, he gave a characteristically eloquent insight into the passion that informed his own work at the bar. He said, "The bar captures the mind and governs the life of those who join it. Its rewards are sometimes financially parsimonious. It is a profession to be entered only by those who have a passionate desire to be a barrister. But that is the best of all reasons. For those, the experience of practice does not disappoint." Some idea of his passion for the work of the bar and for the life of a barrister can be obtained from the oral history held by the Supreme Court of Queensland in the record of a conversation between Sir Gerard and Mr. John Gallagher KC in 2002. This conversation is well worth reading, as well as an enduring example of Sir Gerard's genuine enthusiasm for the life of the bar. In this regard, I speak of conversation advisedly, because John Gallagher began by asking a question which Sir Gerard stopped answering after about 36 closely typed pages. And I exaggerate only slightly. As much as Sir Gerard loved the work at the bar, he loved his work on the court even more. As I've said, his time on the court was a time of landmark changes in the perspective of the High Court. In relation to some of those landmark changes, he was an important ally to Sir Anthony Mason, who was the leading spirit. The radical re-understanding in Cole and Whitfield of Section 92's constitutional guarantee of freedom of interstate trade, commerce and intercourse is the most momentous example. In that case, the High Court resolved much of the vexation and uncertainty that had attended the operation of Section 92 since Federation. The decision in Haar and New South Wales had much the same effect in relation to Section 90 of the Constitution, which confers exclusive power on the Commonwealth over the levying of duties of customs and excise. In other areas of the law, though, Sir Gerard himself was the more dynamic influence. His great decision in Mabo, with which Chief Justice Mason and Justice McHugh agreed, is the most famous example. A somewhat less celebrated example is the judgment in Longy and the Australian Broadcasting Corporation. The unanimous judgment of the High Court in that case ensured that the freedom of political communication, earlier said to be implicit in the Constitution, survived a series of challenges based largely on the uncertainty generated by the diversity of attempts to articulate the basis of the freedom and its incidents. The unanimous judgment of the High Court ensured that the idea of a freedom of political communication implied as a matter of indispensable necessity in the realisation of the representative democracy established by the Constitution would not be consigned to the historical scrap heap of failed judicial experiments. A further, perhaps less well-known example of his practical leadership of the court was manifest in the court's willingness to devote a greater part of its time to the development of the criminal law and to ensuring the due administration of criminal justice. In the area of tort law, his principled and steadfast, and for some time rather lonely, opposition to the idea of proximity as a controlling concept in the law of negligence was ultimately vindicated, although this would not be seen to be clearly the case until after he had left the court. The High Court's jurisprudential flirtation with the proximity heresy reached its nadir in its decision in Bryan and Maloney. The dissenting judgment of Justice Brennan in that case would, as I say, ultimately be vindicated. But what is particularly remarkable about that judgment, for my purposes this evening, is the respectful manner in which he stated his position. In explaining the errors in the majority position, he was, as always, moderate in his language, refraining from the kind of personal attack and vituperation that is apt to diminish public confidence in the courts. To that topic I will return. His term of leadership of the High Court as Chief Justice of Australia was of course quite brief, only 3 years. Paul Keating told me that when the decision to appoint Sir Gerard as Chief Justice was made by his government, there were some within the government who argued that an appointee as Chief Justice should have a longer term in office than 3 years. Keating silenced those doubters by insisting, no doubt in his characteristically emphatic way, that the period of time in office was of less importance than the clarity of the appointee's moral compass while in office. It was his firm view that in this respect, Sir Gerard was the outstanding candidate for the office. Time would confirm the wisdom of Keating's assessment. Can I take a moment to say that Keating, the political hard man, greatly admired Brennan, the compassionate intellectual, for the integrity with which Brennan exercised his powers as a judge. Keating's assessment of the stability of Brennan's moral compass reflected an insightful appreciation that Brennan was above petty or partisan considerations, including the tribalism that has sometimes been a problem for Irish Australians and for our fellow citizens as a result. Brennan remained faithful to the compassion that is the best element of the Catholic faith that was so dear to him and so central to his view of the world. When one considers Sir Gerard's jurisprudence as a whole, the injunction in Matthew 7:1 judge not, lest ye be judged, comes to mind. St Matthew's exhortation was not a denial of the legitimacy of the judicial function. That's abundantly apparent from its context. In truth, it is a direction to recognise the limits of one's authority over others. It is a direction in favour of judicial modesty. It is reflected in the notion that the first duty of every tribunal is to satisfy itself as to its jurisdiction over the matter before it. It is a direction to refrain from arrogating to oneself the authority reposed by law in others. Sir Gerard's great example to those who came after him was to temper compassion, the greatest of the human emotions, in the desire to do justice, with modesty, that rather rare judicial virtue. All of which leads me to the title of my remarks this evening, and to what some might see as a tension in his significant judgments between his personal views, his deeply felt compassion for others, his deep commitment to the cause of Indigenous Australians, and his adherence to the legal rules to which he was obliged to give legal effect as a judge. The most poignant example of this tension is provided by his judgment in the Wick case, in which he adhered to the legal analysis which was the foundation of the landmark decision in Mabo. There would be little doubt, I think, that among Sir Gerard's many significant contributions to Australian law, his most famous was his leading judgment in the decision in Mabo in 1992. In that decision, it was held that the common law of Australia recognised that the rights of occupation of Australia's Indigenous people in their ancestral lands, and that these rights survived British settlement under the Crown. 5 years later, in the Wick case, Chief Justice Brennan, as he had become, dissented from the majority view that these rights had not been extinguished by historical grounds by the Crown of pastoral leases under colonial and state legislation prior to the enactment of the Racial Discrimination Act in 1975. I suggest that the key to understanding the consistency of his judgments in these two cases lies in an appreciation of Sir Gerard's fidelity to the constraints upon judicial decision-making required by the constitutional separation of legislative and judicial power. Before turning to discuss these cases directly, I want to say something about some other cases in which he explained the constitutional underpinning of his view of the limited scope of legitimate judicial lawmaking. I will then go on to suggest that this understanding remains the orthodox view of the separation of powers enshrined in our constitutional arrangements. That orthodoxy may now be subject to challenge from a number of perspectives, but a very different constitutional order would emerge if it were to be displaced. Justice Brennan's understanding of the relationship between legislative and judicial power is crisply stated in his judgment in Dietrich and the Queen, decided in 1992. In that case, the argument put for Mr. Dietrich was that an accused person charged with a serious crime, punishable by imprisonment, who cannot afford counsel, has a right to be provided with counsel at public expense. The High Court held that no such right exists under the common law, but the majority were nevertheless able to reason to a conclusion that vindicated Mr. Dietrich's claim that he should not have been tried without the benefit of legal representation. Justice Brennan dissented. The position in Australia stands, of course, in stark contrast with that in the United States, where the Sixth Amendment to the US Constitution expressly provides, quote, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defence," unquote. And so, in Johnson and Zerbst, the US Supreme Court held that in all federal cases, a court must appoint counsel to represent defendants who are unable to afford their own. The Supreme Court said, since the Sixth Amendment constitutionally entitles one charged with crime to the assistance of counsel, compliance with this constitutional mandate is an essential jurisdictional prerequisite to a federal court's authority to deprive an accused of his life or liberty. If one thing is clear in this field of discourse, it is that neither our federal constitution nor any of the state constitution contain a provision remotely resembling the Sixth Amendment. The argument in Dietrich that an individual enjoyed a right to be provided with counsel at state expense could not stand with the constitutional provisions and with the constitutional role of the judiciary. As Justice Brennan explained, the courts can point out that the administration of justice is an inalienable function of the state and that the very security of the state depends on the fair and efficient administration of justice. But the courts cannot compel the legislature and the executive to compel legal representation, nor can this court declare the existence of a common law entitlement to legal aid when the satisfaction of that entitlement depends on the actions of the political branches of government. In my opinion, to declare such an entitlement without power to compel its satisfaction amounts to an unwarranted intrusion into legislative and executive functions. In Dietrich, the majority of the judges held that the power of the courts to ensure a fair trial of a criminal charge extends to granting a stay or adjournment of the trial while representation of the accused, where representation of the accused is essential to a fair trial, as it is in most cases where an accused is charged with a serious offence. That view was based on the proposition that judicial power should not permit itself to be deployed unjustly. Justice Brennan explained his rejection of this reasoning. He said, although the desirability of according an entitlement to legal aid is manifest, the critical legal question in this appeal is whether this court can and should translate that desirability into a rule of law, or, if there be any difference, into a rule of practice governing the conduct of criminal proceedings. In my respectful opinion, this court cannot properly create such a rule. He noted first that the common law has never recognised such a rule. He then observed the difference between our constitutional law and the constitutional law of countries like the United States, which have empowered their courts to construe broadly expressed guarantees to include a right to counsel. Next, he noted there is no valid analogy between cases of unfairness which result in a miscarriage of justice and cases in which an indigent person charged with a serious offence goes unrepresented, for the reason that many trials of unrepresented persons do not result in a miscarriage of justice. It was a matter of logic. Justice Brennan concluded with this observation: the courts do not control the public purse strings, nor can they conscript the legal profession to compel the rendering of professional services without reward. The provision of adequate legal representation for persons charged with the commission of serious offences is a function which only the legislature and executive can perform. No doubt demands on the public purse, other than legal aid, limit the funds available. This understanding of the relationship between legislative and executive power on the one hand and judicial power on the other is rooted in the history and traditions of the common law. In the history of the common law, the King's judges were, with their juries, responsible for the development of the rules of common law subject to the ultimate sovereign authority exercised by the King in Parliament. From the time of Henry II, the courts of common law had, by their decisions, created a body of rules in relation to both civil and criminal law, which they continued to develop. Subject to possible intervention by the King in Parliament, the judges of the courts of common law were masters in their own house, and certainly by the late 18th century, English judges had demonstrated their firm resolve in the defence of common law rights to liberty and property, these being rights that they had themselves created. That a judiciary largely drawn from the aristocracy and gentry for hundreds of years should have been zealous to defend the common law rights of landed aristocracy and gentry against encroachment by central government is hardly surprising. It's not unduly cynical to observe that the judges were enforcing rights of property enjoyed largely by the classes of which they were members. Parliament over time became more and more responsive to the claims of the merchants and professionals of the middle class, and even ultimately to the claims of working people at the expense of land-based wealth. Even then, the judges were astute to insist that rights of property would be diminished only by the clearest expressions of legislative intentions to do so. It's one thing to look to the courts to stand between individuals and the executive government to ensure that individual rights, recognised by the common law, are protected from the arbitrary exercise of state power. The enforcement by the courts of rights of this negative kind, that is, the right to be left alone by governments, to enjoy rights to liberty and property under the common law, costs the community nothing in the upholding of those rights, at least not directly. It's another thing for the courts to assume the role of creators of positive rights, that is, rights to an education, to healthcare, to support for those affected by disability, adversity, or old age. The common law never built a school or a hospital or cared for the veterans of England's many wars. As Justice Brennan noted in Dietrich, to vindicate these rights, money must be raised by taxation and then allocated between competing priorities about which there will be contention. In our legal tradition, these responsibilities over the centuries became, and still remain in the orthodox view, the province of the legislature. This was not inevitably the case. In England, they fought wars about it. Our constitutional arrangements are the outcome of 1,000 years of political, economic and social conflict, beginning shortly after the Norman Conquest. These roiling conflicts were manifest in the wars between Simon de Montfort and Henry III and Edward I, in the political struggles to finance the 100 Years' War, and in the revolution in England, which convulsed the British Isles for most of the 17th century. Within the legal tradition shaped by these conflicts, government evolved from the armed and violent kleptocracy of William the Conqueror and his descendants to the liberal democracy of the 19th century, and ultimately after World War II to the welfare state. The central element in the constitutional settlement following the revolution of the 17th century was that the raising and expenditure of public monies became the exclusive province of the legislature, which represented the political nation. Neither the executive nor the judicial branch of government may insist on the extraction of money from the citizenry or the expenditure of public money, however worthwhile the objects of that expenditure may be, without legislative authority for the exaction and the appropriation. This point of view is the essential basis of the decisions of the High Court in the State School Chaplains cases decided in 2012 and 2014. The classic and perhaps the most famous statement of this aspect of the relationship between the three branches of government which developed at Westminster in the 600 years to the end of the 18th century is contained in the Federalist number 78, written by Alexander Hamilton. In that essay, Hamilton famously wrote, "The executive not only dispenses the honours but holds the sword of the community. The legislature not only commands the purse but prescribes the rules by which the duties and rights of every citizen are to be regulated. The judiciary, on the contrary, has no influence over either the sword or the purse, no direction either of the strength or of the wealth of the society, and can take no active resolution whatever. It may truly be said to have neither force nor will, but merely judgment, and must ultimately depend upon the aid of the executive even for the efficacy of its judgments." Hamilton's statement is not theoretical or prescriptive. He is not saying what ought to be the proper role of each department of government in an ideal world. Rather, his statement is an elegant summary of historical experience, the historical experience of the English-speaking peoples after the revolutions of the 17th century. It may be objected that Hamilton's summary was altogether too elegant. The rules of the common law had been created by judges and juries over the centuries before the idea of the separation of powers crystallised and took hold, and Parliament exercised judicial power from time to time, most notably through the enactment of Bills of Attainder. The idea of the separation of powers was an idea whose time had come only by the end of the 18th century. It was given its strictest expression in the US Constitution, which divides legislative, executive and judicial power. In the Australian Constitution, the boundary between legislative and executive powers is untidy and porous, especially as a result of the adoption of the model of responsible government in which the exercise and retention of executive power depends on maintaining the confidence of the lower house of the legislature. On the other hand, the division between judicial power on the one hand and executive and legislative power on the other is much more strictly drawn. That strict separation has ensured the independence and impartiality of those charged with the exercise of judicial power, but it also tends to ensure that what might be perceived as the moral shortcomings of the people's representatives in their legislatures are not subject to correction on that account by judges who are not themselves answerable to the people. It's the legacy of the historical experience summarised by Hamilton of the characteristic activities of these three branches of government that have shaped our Constitution. It may be that this legacy does not now resonate with the zeitgeist, or within the zeitgeist, as strongly as it did. It may be seen that its force is challenged in cases such as Dietrich that came before the High Court on which Justice Brennan sat. Those challenges have not gone away. In the ongoing debate about the relationship between the state and the individual, there is a point of view that the absence from the Australian Constitution of guarantees of individual rights analogous to those contained in the Bill of Rights in the US Constitution is greatly to be regretted. There is also a view that any worthwhile set of constitutional guarantees of the rights of the individual should include positive guarantees of rights such as the right to an adequate education or to adequate health care or to a social wage, whether one actually works for it or not. In the orthodox perspective espoused by Justice Brennan, the formulation and promulgation by the courts of such positive obligations must necessarily exalt the position of the judiciary and so diminish the constitutional role of the legislature. Within the orthodox view, when the Constitution, as interpreted by the courts, operates to strike down laws that are inconsistent with its provisions, the inconsistent law simply has no operation at all. The legislature is left to attempt to frame a law that is consistent with the Constitution, as similar in effect as can be found with the law that has been struck down. Of course, in some cases, the inconsistency between the substance of the impugned law and the constitutional prohibition may be such that no effective replacement law is possible. But if a constitutional scheme like the Bill of Rights were to create positive individual rights, such as the right to adequate education, a right to adequate health care, or a right to a minimum wage, sufficient to sustain a fair and reasonable standard of living for all residents of the community, then the possibility must arise of the courts not only striking down a law that is adjudged to be inadequate in meeting the constitutional standard, but of going further to declare the terms of the law necessary to meet the constitutional standard. Now, it might be objected that for the courts to assume such a role would be to usurp the constitutional function of Parliament. It would certainly be fair to say that the performance of such a role is difficult to square with the established function of the courts under our constitutional arrangements. But as a matter of logic, if one accepts that the constitutional function of the courts is to declare what the law is, then there does not seem to be much basis for objecting to the courts declaring what the law actually requires in a given case. In any given case where a person asserts a failure by the state to provide a positive constitutional guarantee of an adequate education or healthcare or minimum wage, why should not the courts respond to that assertion? A breach of the constitutional guarantee could be shown by an aggrieved person showing that the constitutional standard has not been met in the circumstances of the particular case, and the court should say what is required to meet that standard. That would be a long way from the orthodox view, and it would be a long way from our current constitutional practice. And yet it may be that the grip of the orthodox historical perspective is slipping, especially on the minds of the younger generation. Each year, the best and brightest of our young graduates emerge from our universities, almost all of them fired by the ambition to work in the field of human rights, which they understand is involving working within the judicial system to bring positive improvements to other people's lives. Almost without exception, none of them ever expresses an ambition to enter politics. Given the cynical brutality of the political process and the eye-crossing banality of so much of what passes for political debate, one can understand the consequent disillusionment with the political processes of government, which seem so slow to do basic justice to the disadvantaged. One can understand the attraction, especially for our best and brightest young lawyers, passionate to see justice done, of arguing for rights in the open, polite and reasonable atmosphere of a court, whose decisions must be justified in public by comprehensive reasons. In the orthodox perspective on judicial power, the attractions of the openness, fairness and rationality offered by the judicial process cannot trump the stubborn truth that the grant of positive rights necessarily depends on the exercise of the sovereign prerogative of choice between the good and other goods and the not so good, and that positive rights are possible in a democracy only if taxpayers are willing and able to pay for them. For Justice Brennan, as he explained in Dietrich, within the legal tradition of the common law as it has evolved and under our Constitution, predicated upon that evolution, it was only the institution of Parliament that could create the positive rights that give practical meaning to the great political idea of fraternity, without injustice to those of the citizenry who must pay for those rights, even though they themselves may derive no benefit at all from the allocation of society's resources. To declare and enforce such rights against all the people of a community who have not agreed to pay the price puts one in mind of St Augustine's description of a state without justice as nothing more than a great band of robbers. In Australia, the great political principle of fraternity has, as a matter of historical fact, thrived to an extent that is the envy of the world. That success has been dependent upon an engaged citizenry rather than upon the wisdom or generosity of judges. Those of us who know something of our country's history have ample reason to have faith in our parliaments to create positive rights for our citizens. The Honourable E.G. Whitlam once said, "Parliament has been our great liberating force. There is no freedom without equality. To redistribute and equalise liberty has been one of the principal functions of Parliament. Parliament alone can give equality of opportunity and thereby increase liberty for all. If we are to have economic equality of opportunity, which is the next stage in the advance of liberty, we must have effective parliamentary government and accordingly dispense with fetters on Parliament rather than contrive them." Sir Gerard Brennan found Gough Whitlam a most interesting politician, but his admiration was not unqualified. I'm reasonably confident that Sir Gerard did not agree with everything that Gough Whitlam ever said or did, but there can be no doubt that Sir Gerard's understanding of the relationship between legislative and judicial power was profoundly in accord with the notion that the parliaments elected by our people are the exclusive source of the positive rights that we Australians enjoy in such abundance. Justice Brennan had no truck with arguments that the Constitution enshrined some deep unspoken limitations on legislative power. Limitations of the kind spoken of by Sir Edward Cook in Dr. Bonham's case. For example, the blue-eyed baby style of argument, by which I refer to the rhetorical device deployed by advocates and sometimes by judges to deny the validity or effect of legislation on the basis that the exercise of legislative power is limited by the inviolability of fundamental legal rights. The blue-eyed baby's idea is the idea that a law requiring the murder of all blue-eyed babies at birth couldn't be a law authorised to the Parliament. This rhetorical strategy invokes the approach famously adopted by Sir Edward Cook in Dr. Bonham's case. Sir Edward Cook had said, "In many cases the common law will control acts of Parliament and sometimes adjudge them to be utterly void. For when an act of Parliament is against common right and reason or repugnant or impossible to be performed, the common law will control it and adjudge such act to be utterly void." More recently in Fraser and State Services Commission, Lord Cook of Thornton spoke of some common law rights which may go so deep that even Parliament cannot be accepted by the courts to have destroyed them. To the extent that this rhetorical device involves an appeal to a strain of natural law thinking or to personal intuitions of what is right and proper, it is tempting to dismiss it out of hand as fundamentally undemocratic. The blue-eyed baby's argument postulates a community gone mad, and so it's not a reasonable test of the validity of a law made by a community that has not gone mad. But it represents a persistent style of argument that has come in and out of fashion over the years. It's a hardy perennial, being a favourite of those who take an expansive view of judicial power. It's a kind of argument that Brennan never encouraged. He certainly never deployed it himself. I venture to suggest that in point of authority, he would have regarded it as contrary to the engineer's case, and in point of principle, he would have regarded it as contrary to the dignity of the people of the Commonwealth to approach the interpretation of legislation on the basis that the members of the judiciary were possessed of a wisdom and goodness beyond that shared by the people of the Commonwealth and their elected representatives. So, coming then to the decision in Mabo. Sir Gerard's understanding of the limits of legislative power that underpinned his reasoning in Mabo was not sourced in common law notions or in natural law notions that some things are not permitted to the legislature. Rather, it was based on the compelling constitutional consideration that the federal system, and particularly Section 109 of the Constitution, subordinates the statute laws of the states to the laws of the Commonwealth in cases of inconsistency. It was strictly on this basis that he was to hold in Mabo that the Racial Discrimination Act 1975 of the Commonwealth operated to ensure the continuing enjoyment of Indigenous occupation of land recognised by the common law that had not been previously extinguished by state legislation. While it was well within the province of the judges to recognise and give effect to the common law rule that acknowledges the peaceful occupation and enjoyment of land as a matter of Indigenous custom, that common law position was inherently vulnerable to alteration by legislation, at least until the enactment of the Racial Discrimination Act. Justice Brennan's understanding of the common law rights of Indigenous people in the peaceful occupation of their traditional lands was in harmony with the deepest values of the common law. From the earliest moments of the common law's self-consciousness in the 12th century, the courts of common law were astute to vindicate the rights of those in peaceful occupation of land against any intruder who could not show a legal title that trumped their peaceful possession. When the common law travelled over the seas, that is how it still saw things, at least when it was not blinkered by the fiction of terra nullius. But that position could be displaced by the exercise of sovereign power, and within the web of sovereign authority exercised by the officers of the executive and judiciary, bound to the imperial crown by oaths of office and allegiance, the only sovereign authority was that of the Crown and Parliament. As a matter of the very nature of sovereign authority, there can only be one. I come now to the Wick case. I should by recalling that in the course of the hearing, the argument put for Queensland was that because of the vulnerability of native title to extinguishment by the exercise of sovereign power, the grant to pastoralists of exclusive possession of land by Crown leasehold established any right that might have been asserted by native title occupants. In the course of that argument, Chief Justice Brennan responded with what was nothing less than a cri de coeur. He said that in this way Aboriginal communities had been destroyed. This was one of those extraordinarily dramatic moments that occasionally happen in courts. These moments aren't captured in the transcript, and the drama is certainly not captured in the law reports. The Chief Justice's observation was followed by what seemed like a very long moment of silence in the courtroom. I can attest that it certainly seemed like a very long time to the wretched barrister who was appearing for Queensland. The Chief Justice's anguish was real and genuine and palpable. Counsel for the State of Queensland could say nothing in response. With the benefit of hindsight, the moral delinquency of what had happened was indefensible. Quite a few people observing the proceedings quickly formed the view that the Chief Justice's likely disposition of the case was clear. In the event, though, Chief Justice Brennan held that if it be right to hold that the grant of pastoral leases extinguished the native title of the traditional Aboriginal inhabitants, the law will be held to destroy the legal entitlement of the inhabitants to possess and enjoy the land on which they have lived since time immemorial. That would be a significant moral shortcoming, he said. He held, nevertheless, that the shortcoming cannot be remedied by denying the true effect of the Queensland statute and of the pastoral leases granted under it. The true effect of the Queensland statute was to be ascertained by the application of the general law as to the interpretation of statutes, and much as it plainly galled him personally, he accepted that he was obliged to hold, in the end, that the morality of the legislation was a matter for the legislature as the elected representatives of the people. The issue on which the decision in Wick turned was whether the statutory provisions under which the pastoral leases were granted provided for the conferral of a right of exclusive possession on lessees from the Crown. And that is to say, whether the lessee was granted the right to exclude all others, including Indigenous people, from the land the subject of the grant. Chief Justice Brennan was unable to regard the grant of a lease under the Land Act, being the relevant Queensland law, as doing other than conferring the right in a lessee to exclude all others. Underlying the contrary view, the view that prevailed, was the notion that the legislation that authorised the grant of a pastoral lease should be read down so as to deny to pastoralists the right to exclude some other people on the land, being native title holders, from their ancestral lands. It might be said that this majority opinion involved the attribution of a degree of solicitude for the interests of Indigenous occupants of land that proceeded on an ahistorical understanding of legislative intention to open up the wastelands of the Crown in Queensland to exploitation and development by the settlers. The question also was not whether pastoralists had purported to exercise their right to exclude others from the land, but whether they were entitled to do so under the terms of their grant. and the entitlement to exclude all others from leased land is the characteristic entitlement of any lease. In order to avoid that critical obstacle, the reasoning of the majority had to confront substantial legal authority. Some might think the majority attempt to do so was compelling, but Chief Justice Brennan was unable to see his way clear to ignoring the settled understanding, recently affirmed by the decision of the High Court in 1981 in American Dairy Queen and Blue Rio, that when the Queensland legislation spoke of a lease, it was necessarily speaking of a lease, the incidents of which are those of a lease at common law, and which include the right to exclude all others from the leased land. To ignore that well-settled understanding by reading the legislation in a strained or artificial way would, in his view, have been impermissibly to second-guess the legislature. Whatever one's view about the majority's interpretation of the particular legislation in the Whig case, experience elsewhere demonstrates the practical wisdom of Justice Brennan's constrained understanding of the scope of judicial power. To reflect on the experience of the United States, for example, is to see the abiding importance of recognising the constitutional constraints upon the personal moral values of the judges as a dynamic in judicial decision-making. In the United States, issues about judicial appointments divide political parties and the nation in a way that is happily quite foreign to our experience. In Australia, the appointment of judges to the High Court almost never generates political controversy. In the United States, the appointment of judges to federal courts, and especially to the Supreme Court, is an issue of fundamental political importance in which all politically engaged citizens have a vital interest. Recent experience in the United States reflects the response of the community to the work of a judiciary, itself now highly polarised ideologically, that has shown itself to be willing, and indeed anxious, to shoulder what it sees as the necessary burden of making the great political and moral decisions that the other branches of government seem to be unable to make, or at least to make satisfactorily to the interests of those who object to them. The judiciary has been punished as a result by a political backlash that reflects a loss of confidence in the institution as an independent arbiter of the people's disputes. In this regard, CNN's exit polling at the 2016 presidential election disclosed that for 56% of those who voted for the Republican candidate, the issue of Supreme Court appointments was the most important factor in their vote, with only 37% saying that the issue was not important to them at all. The Republican candidate well understood the state of affairs reflected in these figures. Indeed, his appreciation of the point was a major part of his political strategy. He told a rally in July 2016 that even if Conservative voters didn't like him, they would have to vote for him anyway. You know why, he asked? Supreme Court judges, he answered. And in this regard, as events have shown, he proved as good as his word, appointing Supreme Court and federal judges to resounding applause from his political base and to the dismay of the other half of the population. For several decades now, there have been on the Supreme Court of the United States judges who find the prospect of what they see as a significant moral shortcoming in the outcome proposed by other members of the court, not only as a reason to set at naught the decisions of the legislature, but also as an occasion to engage in direct and personal attacks on their fellow judges in the case, for the reason that they have a different moral and political viewpoint. These attacks serve to delegitimise the judicial function. A strong, but not atypical example of this latter problem can be found in the observations of the late Justice Scalia in Obergefell and Hodges, the same-sex marriage case. His Honour attacked the majority opinion which favoured constitutional recognition of gay marriage in the following terms. The opinion is couched in a style that is as pretentious as its content is egotistic. The opinion's showy profundities are profoundly incoherent. In the famous footnote 22, Justice Scalia went on to say, if, even as the price to be paid for a fifth vote, I ever joined an opinion of a court that began, quote, the Constitution promises liberty to all within its reach, a liberty that includes certain specific rights that allow persons within a lawful realm to define and express their identity, I would hide my head in a bag. The Supreme Court of the United States has descended from the disciplined reasoning of John Marshall and Joseph Story to the mystical aphorisms of the fortune cookie, unquote. This sort of vituperation may be amusing to some. It may perhaps not be out of place in an academic law journal, but on any view, it has no place in a judgment of a court. As a purely practical matter, once the members of a court begin to attack each other as traitors to their judicial oath, or on the grounds of moral delinquency or deficiency, the public has little reason to retain confidence in the institution at all. That is especially so where the court is concerned to resolve great political and moral questions, contrary to the will of the people's elected representatives in their legislatures. These practical considerations aside, as a matter of principle, it is necessary to recognise that these great questions are very difficult. Honest and reasonable minds may differ. As St Augustine said, on great questions, unanimity of opinion is the privilege only of angels. No judge is wise enough or good enough to make adverse judgments about the morality or of the wisdom of that judge's fellow judges to resolve the controversies that confront them. Making such judgments is no part of the role of any judge, just as it is no part of the role of any judge to judge the morality of wisdom of the legislature. The United States experience offers a salutary warning of what can happen when judges fail to heed Matthew's advice to judge not lest ye be judged. The modest restraint that informs the great judgments of Sir Gerard Brennan remains an essential part of the legacy that continues to inspire and guide our lawyers and judges, certainly the judges of my generation. I commend it to the lawyers and judges and to the people of the next generation. Thank you for your attention.
Thank you so much, Justice Keane. I'm sure Sir Gerard Brennan would be delighted with your comments today. And now we have the judge's eldest born son, Father Frank, to respond to Justice Keane. Thank you.
Patrick Keane was 1 year and many streets ahead of me at law school. We were admitted to the Queensland Bar on the same day. I was privileged to have the legendary Dan Casey move my admission. Casey informed the court, "In moving this motion today, I cannot help but go back along the corridor of time, and indeed it is with a considerable emotion of nostalgia that I, as an old man, am able to have the privilege of moving the admission of the third generation of Brennans associated with the law. I was, of course, very closely associated with and ably assisted, and in many cases directed by his father, now Mr. Justice Brennan, when on many occasions he and I worked together, particularly in defamation cases. My father idolised Casey. He was fond of recalling that Sir Owen Dixon had said that there was no place in Australia that had another Casey. Dad was greatly humbled by those words from Casey, as he would have been by the words of our distinguished speaker this evening, acknowledging that Sir Gerard, in his professional life as a barrister and a judge, which encompassed the 5 decades after the end of World War II, was without peer, save for Sir Anthony Mason, in the contribution he made to the administration of justice in Australia, and that since Dad's retirement, the work of Australia's highest court can be seen to consist in very large part of the working out and consolidating the landmark developments in the law in Australia wrought by the courts in which Sir Anthony and Sir Gerard participated and over which they respectively presided. As one unaccustomed to appearing in court, I'm honoured to speak now in the court where my grandfather, after whom I am named, was a judge, and in the court where my father so often applied his considerable advocacy skills while at the bar. I'm humbled to be asked to propose the vote of thanks, as I know that one of Dad's daughters, a Silk, is in the audience, as is one of his granddaughters, a Silk from another jurisdiction. This evening, Pat Keane has, with his usual and graceful dexterity, highlighted the constrained compassion of Brennan in his judgments and in discharging his office as judge. Might I add one further dimension to the contrast Pat provided between my father's judgments in Mabo and in Wick? I'll provide a contrast between Brennan the advocate and Brennan the judge, addressing the claims of Aboriginal peoples to their traditional lands. While Pat and I beavered away in the law school library 50 years ago, him more than me, Brennan was president of the bar here, spending considerable time away as the senior counsel for the Northern Land Council in the Woodward Royal Commission on land rights in the Northern Territory. This was part of Brennan's oral submission to the Commission on the 1st of March 1974 in relation to pastoral leases. Mention was made as to whether or not the national interests of Australia required that there be preserved from Aboriginal ownership a major portion of the pastoral portion of the Northern Territory in order that its development may continue and its productivity be furthered in the light of the protein shortage which faces the world today. Two questions may be asked, he said. One is, who's going to eat the protein that is going to be so developed? And our concern would be, of course, that the protein should be available for consumption by Aboriginals in the first instance. Is not the real question which is raised by this observation, he said, the question of whether cattle are more important than people? The sort of cry that one has heard so often from Aborigines in the Northern Territory, and in our submission, when one evaluates the importance of the land with, let it be assumed, a diminished productive capacity, and places that against the prospect of Aboriginal isolation from the land and increased production capacity, the national and international submission is to be answered in only one way, in terms of Australia's international necessity. Australia's international interest is to be served by demonstrating an understanding and compassionate concern for our Aboriginal people. Brennan's passionate advocacy failed to convince the Commissioner, and it was not until Wick that traditional owners obtained some recognition of their rights to their traditional lands on pastoral leases. Patrick Keane has pointed out that 4 years after his majestic judgment in Mabo, Brennan, then Chief Justice, dissented in the Wick case, which considered whether native title could coexist on a pastoral lease. The court decided 4-3 that native title could coexist. In Mabo, Brennan had written the lead judgment for the majority in a 6-1 decision. In Wick, he wrote the lead judgment for the minority in that 4-3 decision. Before Woodward, Brennan had argued forcefully for the recognition of Aboriginal rights on pastoral leases. Then he was the compassionate advocate. Now he was the constrained judge on the final Court of Appeal. He thought there were limits to how far the courts could go. In Wick, the plaintiffs proposing the coexistence of native title rights on a pastoral lease argued that any limitation on pre-existing native title rights would be contingent on the pastoralist taking legally authorised action on the pastoral lease, such as the fencing of the land. They argued that prior to the taking of any such action, native title could continue to exist. In dissent, Brennan rejected this submission, saying, "The law can attribute priority to one right over another, but it cannot recognise the coexistence in different hands of two rights that cannot be both exercised at the same time. To postulate a test of inconsistency, not between the rights, but between the manner of their exercise, would be to deny the law's capacity to determine the priority of rights over or in respect of the same parcel of land." Brennan, the judge, willingly conceded that this reasoning could produce an injustice, but he was constrained by his understanding of the judicial function and the need for the common law to maintain certainty. Let's recall the exchange between Brennan and our speaker during the Wick hearings on the 12th of June 1996. Pat, as Solicitor General for Queensland, had observed that there was recognition from the start by legal authorities in the colony of New South Wales and at Whitehall that the effects of the pastoral leases was to create a right in the grantees to turn other people off. Justice Kirby intervened. The appellants ask where were those thousands to go if they were all to be turned off as trespassers. Pat responded, "Your Honour, that was the problem that confronted the authorities here, and this court recognised that as pastoral leases expanded, concern for the dispossessed Aborigines mounted. As the pastoral leases expanded, dispossessed Aborigines. It occurred, it happened." The Chief Justice observed, and Aboriginal society was oftentimes destroyed. Pat tells us that they're followed by what seems like a very long moment of silence in the court. I can attest that it certainly seemed like a long time to the wretched barrister appearing for Queensland. Brennan's real and genuine anguish was palpable. The transcript shows the Solicitor General simply answered, "Yes, Your Honour." In his judgment, Brennan concluded, "The Wick and Thayor people's claims fail because native title was extinguished on the issue of the leases. The principles of the law may thus be thought to reveal a significant moral shortcoming, which can be rectified only by legislation or by the acquisition of an estate which would allow the traditions and customs of the Wick and Thayor peoples to be preserved and observed." Brennan's judgments in Mabo and Wick nicely highlight the creative tension he lived and thought as a judge of constrained compassion, committed to the rule of law and to justice for all. As a barrister, he'd become convinced of the justice of Aboriginal claims to land rights. But on the bench, his passion for justice was tempered by his judicial oath to do right to all manner of people according to law, without fear or favour, affection or ill will. Having taken that oath as Chief Justice on this very Bible, he said, "The oath requires justice to be done according to law. In appellate courts, the law may authorise a tension between abstract justice and a rule of law to be resolved by an alteration of the rule. The jurisdiction of the court is fixed by law, and judgment must be rendered in accordance with judicial method." But I think it needs to be conceded that the resolution of that tension often depends on the constitution of the bench, particularly on the diverse personnel who are on the court. So, if I might just share one anecdote of the legislative process after Wick. I was in the parliamentary rooms of Gareth Evans at 3 a.m. one morning with the excitable Darryl Mellom, who was a great advocate of Aboriginal rights. You will recall with the Mabo judgment, which had a bench which included Justices Mason and Dean, it was thought, I think rightly, that if that court had considered the matter of pastoral leases, then the court would have decided by 4-3 that native title would have been extinguished. Brennan would have written the main judgment. It turned out that Sir Anthony Mason was replaced by Bill Gummow, and it was thought that Gummow would follow the Mason line. Dean was replaced by Kirby, and everyone knew that Kirby would follow the Dean line. But it turned out that Gummo followed the Dean line and not the Mason line, and so it went 4-3 in the opposite direction. So there we were, and Darrell Mellum said, you know, the Wick decision reconfirms my belief in God. And Evans, as quick as a flash, said, yes, but you didn't know his name was Gummo, did you? And that's often the way the legislators see the judiciary. We thank Pat Keane not only for his splendid lecture this evening, but also for his own faithful adherence as judge to the principles he's outlined this evening. We give thanks that the modesty and restraint that informs the great judgments of Sir Gerard Brennan are an essential part of the legacy that continues to inspire and guide our lawyers and judges of the present and future generations. Join with me in wishing the fourth generation of Brennans in the law and their colleagues well as they wrestle with the demands of judicially constrained compassion. And Pat, now that you've retired from the bench, please accept this fine bottle from John McKenna KC as a token of our appreciation.
I was hoping I didn't have to stand again, but look, thank you, Father Frank, for a superb reply. And if you've never seen Sir Gerard, looking at Father Frank, there's a clear resemblance. He's a little taller, I think, but he has the same certain mannerisms and that same compassion. So look, can I again thank Justice Keane for his superb analysis today, and this is a very important event in terms of being the first retrospective lecture on the jurisprudence of Sir Gerard Brennan, and I hope it won't be the last. So thank you again for coming today.